Can you hear me? Yes. I'll work on that in just a minute. Our next speaker is Jeff Tuomala. Jeff Tuomala is a professor at the Liberty University Law School. It says retired here. He was retired for a short amount of time. I think maybe a year, but he's back again. So Jeff is retired, supposedly retired, but not retired, law professor whose 33-year career at Regent University, Thomas Good Jones Law School, and Liberty University Law School culminated, and it's still going, in designing Liberty's biblically grounded curriculum and signature lawyering skills program. As I said, it's still going now with the foundations course that he's working on. He holds a BS from Ohio State University, The Ohio State University, sorry. A JD from Capital University and LLM with highest honors from George Washington University and completed postgraduate seminary studies. He now writes Christian-focused treatises on constitutional law and jurisprudence and delights in his grandchildren and the careers of his many former students. He's a former Marine Corps judge advocate, former city attorney, former prosecutor, and of course, now in academics. Please welcome Jeff Tuomala. Now, as he comes, let me tell you, he has a couple of booklets up here for you. There are two of them, one in each box. So don't take two from the same box. Take one from each box. Two boxes here on the front row. Right? Did I get it? Okay. All right.
Okay, I'm going to look to my wife. She'll tell me if the sound is... I'm afraid now, after Kevin struggled with it. Let's see. Oh, turn it on? Okay, I think there we go. Okay. Oh, thank you. That's good as long as it's not too loud. People are saying, yes, that works. Okay, well, good afternoon, and thank you, Kevin, for inviting me to speak again this year. Last year I spoke, and the focus of my talk was an article I had fairly recently at that time published called, "Is Tax-Funded Education Unconstitutional?" And the answer is yes. Since that time, in this last year, in my brief retirement, I worked on several different cases, but I worked with Moral Law Foundation, which is Chief Justice Moore's organization in Montgomery, Alabama, on two Supreme Court cases before the U.S. Supreme Court, Mahmoud versus Taylor, and Oklahoma Online School Board versus Drummond. So I've taken what I had in that article and condensed them in a sense and applied them in those two cases. The Mahmoud case was out of Montgomery County, Maryland. That's the one where they had homosexual education, transgenderism, all of that stuff for pre-kindergarten schools. And so we wrote on that. The Supreme Court ruled that the parents had a right to opt their children out of that instruction. I think there are about 160,000 children in the Montgomery County schools, so allowing a few kids to opt out of that is not a huge victory in my mind. That means there are tens of thousands of children just in that school district alone being inculcated in those sort of things. The other is, in some ways, I think more interesting because you had the state of Oklahoma authorizing an online Catholic high school course with tax funding, which means it's very much like a voucher system. In that case, The school board in Oklahoma for online education approved that program. The Attorney General opposed it, so he sued the Oklahoma School Board before the Oklahoma Supreme Court, which found that that funding mechanism violated the U.S. Constitution and the state law in Oklahoma. That went to the Supreme Court. The court ruled 4-4. Justice Barrett recused herself, so that ruling in Oklahoma stands. But there's no doubt in my mind other states are going to try similar funding for online schools, which means they're going to be very much the issues there like you have with vouchers. And if I read this room right, we're not a pro-voucher room, that the state should not be funding education. That's my position as well. So we've got the two briefs that are there. We argued that both of those, that the public school funding is unconstitutional. In the alternative, though, we said the Supreme Court is always saying it treats religion and non-religion the same. Well, why don't you do it in this case? Well, they didn't address those particular arguments, but they're out there. Hopefully they'll be useful again in the future. Now, having followed some other excellent speakers this morning, there's always a temptation to want to comment on something that's said. So I'm going to exercise discretion to do that. I used to teach international law, so I had a special interest in the presentation that Alex Newman gave. My view is, and I learned this from Herb Titus, some of you know him, the UN Charter system is unconstitutional. Only the people can adopt a form of government. That's why we rejected the Articles of Confederation early in our nation's history, had a constitutional convention representing the people that adopted the Constitution. The UN Charter, very much like the Articles of Confederation, was adopted by the legislatures of the various countries of the world, like the Articles of Confederation was adopted by the state governments. So it's unconstitutional. Second, raises an issue: who is going to enforce this Agenda 21 program? Well, under the UN Charter system, it's the Security Council. What if the Security Council doesn't do its job and come around to your schoolhouse, taking your children and putting them in a government school? Well, Jeane Kirkpatrick, who was a UN ambassador during President Reagan's administration, came up with the doctrine that if the Security Council is negligent in its duties, the member states could come around and perform those responsibilities. Okay, I know there are certain things, icons, you're not supposed to talk about, but I couldn't help that one. All right, so the title of this is Jurisdictionalism, or Jurisdictional Perspective, the separation of school and state. And sitting here in the front row is one of my former students, Kevin Novak. He sat in the front row in law school, right about there to my right, and he is the one student who took my approach and what I taught, that the state has no jurisdiction over education, and has really run with it and put it to use. So thank you, Kevin, and it's great to have you and Marcia here today. He also told me his daughter, Reagan, he hoped her first word would be jurisdiction. Was it? Close enough, okay. All right, now, quite often conservative speakers will say, at least they used to, they might be getting away from this now, the words church, separation of church and state are not in the Constitution. And it's true, they're not. But somehow you're to take from that it's okay then for the state to have prayer and Bible reading in the public schools. There's some break in the logic there. I'm not going to try to figure out. There's probably a name for that logical fallacy. But But there's something more important and broad than that, and it's that Congress shall enact no law establishing religion. So think of it this way for the logic class. You've got the genus of established religion. Okay? The species are an established church and an established school. Okay? They're both religious establishments that are prohibited by the First Amendment and probably most of the state constitutions. Now, how would you go about showing that that's unconstitutional to have an established state? Well, it comes down to how do you define religion? And the Supreme Court really has not defined religion. James Madison did in his Memorial and Remonstrance in 1785 in Virginia. He was actually quoting from the Virginia Declaration of Rights. Religion, or the duty which we owe to our Creator. Okay, so that's religion. What's your duty to your Creator? Who tells you what your duty to your Creator is? Well, your Creator. Okay. Now, he made a jurisdictional distinction basically between that which is in the jurisdiction of the state and that which is outside of the jurisdiction of the state, i.e., religion. Those matters that are in the jurisdiction of the state, Madison wrote, can be enforced by force or violence, or directed by force and violence. Everything else is for reason and conviction. It's in the realm of conscience. Your conscience doesn't tell you, it's not what belongs to the state and what belongs to religion. The law of God tells you which belongs to each jurisdiction. When it's in the jurisdiction of religion, it's your conscience that tells you what to do, okay? You're governed by conscience, not by force or violence. So, if you chose to read Curious George, the Federalist Papers, or the Bible to your children, that's for you to determine. That's in the realm of conscience. Now, maybe your conscience should tell you not to read Curious George, okay? I don't want to put a guilt trip on anybody. But it is within the realm of religion. Now, Madison also put forward at that time a bill that Jefferson had written a few years earlier, and it got enacted, the Statute Establishing Religious Freedom, which is still in the law in Virginia. And it sets out two basic principles. One is Almighty God has created the mind free. The other is that it's sinful and tyrannical to tax a person for the propagation of opinions they disbelieve. The whole point of a school system or educational system is to promulgate opinions and facts that we expect the children, hope the children will believe if they're true, okay? So tax-funded education, Jefferson said, is sinful and tyrannical. You can kind of see why the court maybe doesn't want to define religion and go down that route. Unfortunately, Jefferson and Madison changed their minds a few years later, and they were members of the Rockfish Gap Commission, recommending the University of Virginia and a public school system in Virginia. So when you see those signs on bumpers that say, the university, think, oh, Virginia's monument to the enslavement of the mind, okay? All right. And if there are any Virginia people out there, UVA, I do not apologize. Okay, the Supreme Court wrote in Everson, that was a court case that incorporated the First Amendment Religion Establishment Clause into the Constitution, that the objects or purpose of the Virginia statute was the same as the First Amendment. So I would argue, if that's true, and I think it is and should be, they would recognize that the state has no jurisdiction over religion. Okay? Now, how is it that Jefferson and Madison changed their mind from the late 1700s to the early 1800s? Well, either they had a change in worldview, or they were arguing for some particular position when it was convenient, basically as modern-day or at that time, modern-day sophists, or maybe they had a change of mind. Okay? Now, here's how I would explain it. They had a different worldview, at least that they were expressing in 1818 at the Rockfish Gap Commission. And that worldview falsely bifurcated religion and secular. Okay? So things secular could be taught in the public schools. Things religious were in Sunday school or maybe catechism after school or in the home, but somewhere else. So their worldview was one that religion is in the private, personal realm. Secular matters are in the public realm, in the public schools. Okay? That's a mindset that's on the Supreme Court, and it's very evident in a case called Lemon, which is the Lemon test. People can't decide if that case has been overruled or not. It has not expressly been overruled. But what it says, any law that a state passed or the federal government, it must have a secular purpose. Secondly, it must not further or inhibit its primary effect, religion. So they're making a distinction between the two. Have they defined religion? No. Have they defined secular? No. If pressed to define it, how would they define it? I suspect it would be religion is anything that's not secular, and secular is anything that's not religion. Okay? But implicitly, they're two different realms. So a question is, where is that worldview coming from? Okay? I would suggest two primary places it's coming from, at least in our modern day and age. Right? The first is it's coming from a false distinction between faith and reason. Now, I talked to Dr. McFarland over the break, and we had a very nice discussion. I'm not sure if he's still here, but my position is a little bit different, than his on this point, okay? My belief is, and my understanding is, that we start with faith and go to reason. We start with authority, so we have the premises and the basis to reason from. The other approach that's very common amongst Roman Catholics, Thomism, and also a lot of Protestants, maybe most, I don't know, I haven't taken a poll, that we can reason to God's existence without looking at Scripture, independently of God, autonomously. We can come to his belief in his existence. You can get somebody to believe it, and basic principles of right and wrong. Then you can go on to Scripture and show particulars about who God is and other things about right and wrong. Now, I don't know if it's simply coincidental that a majority of the justices on our Supreme Court are Roman Catholics. I'm not saying that this is coming out of that, because this basic worldview was there before we had a majority of Catholics on the court. Okay? The other source that this false worldview, I think false worldview, is coming from is Immanuel Kant, a philosopher from the late 1700s. That comes to us through the mainline liberal Protestant churches and modernist Catholic churches. Okay? Now, instead of nature and grace, they have a distinction between the phenomenal realm and the noumenal realm. And the noumenal realm, religion belongs there, but it's sequestered off into one other little space in the noumenal realm. Religion can't be disproved, it can't be proved, but just stay out of the phenomenal realm. Don't bring your miracles into that. Don't bring your atonement of Christ into that. And secondly, the noumenal realm is the realm of free will. And if religious authority is driving us and speaking to us, then we no longer have free will. You can have whatever religion beliefs you want, but keep them in a separate realm, okay? That's what I believe sustains that position. Now, with Thomas Aquinas and the Roman Catholic view of natural law, the relationship of nature and grace, faith and reason, basically he was trying to synthesize Aristotle in Christianity. An example I can give of that in a non-Catholic school that shows up very prominently is materials I receive out of Hillsdale College. Maybe this is too strong to say they lionize Aristotle, but it's pretty close, okay? And so there's an attempt to synthesize Greek philosophy and Christian theology. And it's not just Hillsdale. I've seen this amongst some people who profess a Reformed view of Christianity. They're Calvinists, but they're Thomist Calvinists, which is a bit peculiar in my mind, but are there. And a couple weeks ago at the law school, we had a guest speaker who came who was very strong on states' rights and that the states should have the power to establish religion or schools in their respective states, okay? And that's somebody coming out of a Reformed Calvinist background. So you've got that kind of a clash going on. Now, Paul had a simple conclusion when he confronted the Greek philosophers in Athens, and his conclusion was, that's foolishness. I know Christ and Christ crucified, and that alone, okay? Scripture. Not sure how long I've talked, but Kevin said would like questions and answers, and my wife told me that last year when I spoke, the best part was the question and answer session. So I'm stopping. I agreed with her, by the way, and she's my biggest fan, so that was not a criticism. So, oh, I'm sorry. I'm not done. You have, if I could just have one more minute, Kevin. Okay. I passed out a chart here. It actually comes out of my article, Is Tax-Funded Education Unconstitutional? And I've got a comparison of the Virginia, the colonial Virginia church establishment, all the things that fell under the jurisdiction of the church. And on the right, the top part of that page, contemporary school establishment. So for example, you can see that the modern state school system has all of the characteristics of the established church in Virginia in the 16 and 1700s, most of that period of time. So for example, state governance of the Anglican Church, state school boards as governing bodies, tax funding for houses of worship, tax funding for schoolhouses. I'm not going to read down through all of those, but it's quite striking. Now, the bottom part of that table is 4 forms of religious establishment. So on the left column, I've got church-state relations. On the other, school-state relations. So for example, common in Europe and in England was a single established church. Everybody had to go to it, and it was state financed. Oregon tried to do this with the state school system in the early 1900s. You must go to public schools. The court struck that down. Okay. Eventually, England had toleration for other groups. So you still paid your taxes to the state church, but you could have your own separately funded state church or a non-state church. The counterpart of that is a single established school with toleration for dissenting churches. That's basically what we've had in the United States for 100 years. Virginia skipped over 3 there in terms of established churches. Patrick Henry introduced the bill, which would in effect be a voucher bill, to fund instruction in moral education through the churches. That was defeated in Virginia, and Virginia went right to a free church, at least in principle. No compulsory attendance, no tax funding. We come over here on the right column. There's been some movement towards multiple established schools. That would be voucher systems and perhaps charter school systems like they tried to implement in Oklahoma. Lastly, we have free schools. No tax funding. They're not supported by the government. No compulsory attendance at the state school. I believe that those counterparts, the counterpart we should have for a free church is a free school system. Okay, Kevin.
Question and answer. Raise your hand if you have a question.
When I was researching my dissertation over 40 years ago, I ran across an interesting quote by William O. Douglas, one of the most liberal of the justices of his day. And it was in one of the Church of Latter-day Saints cases. Well, he was referring to it, but he was giving a definition of religion, which I think you might find interesting. I'm going to have to take off my glasses so I can read. Yes, I had to take my glasses off. Okay. A religious rite which violates standards of Christian ethics and morality is not, in the true sense, in the constitutional sense, included within religion, the free exercise of which is guaranteed by the Bill of Rights. Do you have a comment on that interesting definition?
Now, what could you state the definition there again?
Okay. A religious rite which violates standards of Christian ethics and morality is not, in the true sense, in the constitutional sense, included within religion, the free exercise of which is guaranteed by the Bill of Rights. William O. Douglas wrote that, but not in an opinion.
Okay.
This was in his Book of Days.
It sounds like an example of something, but not a definition that's very helpful, or that I find helpful.
Oh, okay.
Yeah. The court has quoted Madison's definition, but then it didn't go forward with it. It's even included his memorial and remonstrance, as
Yes.
well as the Patrick Henry's bill in an appendix to the Everson case, but they've never really explained it, expounded on it. It just kind of hangs out there.
Yes.
So implicitly, it sounds like that it's quite often we use the term religious, like the religious rites are cultists. That's what it sounds like Douglas is referring to there.
Oh, yeah. I think he was referring to those cases from the 1890s, but it's an interesting comment, and it comes closer to a definition that I can recall in studying all of the cases that I did.
Okay.
Thank you for your talk. It was very interesting. And I, as an advocate for some of these issues, do you see anything in history that suggests that there's a better way to spend our time? Is it better for us to create legislation and get it enacted so that we can fight it through the court system? Or is it better for us to take issues on religion and forcing thereof? Is it better to go after that directly through the courts? Are we better to craft new arguments or to go after the ones that are there?
My belief is first importance is to get it right in terms of the legal principles and the worldview foundation that it's on. And one of the primary things that I hope to accomplish in an article like mine is tax-funded education unconstitutional, is it would be an encouragement to Christians who are homeschooling, Christians schooling their children. This is right, this is proper, this is constitutional. We're doing the right thing here. Not that the Constitution is more important than the biblical principles there. And in my article at the end, I take and lay out the biblical case for what Jefferson and Madison were arguing. So I think that's primary. It looks, my concern in what's going on legislatively, for example, with in Oklahoma, a Bible in every classroom, 10 Commandments in every classroom, and so on. First of all, that's not in the jurisdiction of the state. I'm not sure I want who knows who teaching those things if my children were there. And to put the law of God out by itself outside of the context of the gospel and redemption is really a perversion of the Christian faith. I don't think you can understand or will stick with the ethical and moral standards if you're not first and foremost connected to who God is as somebody to be worshiped.
Thank you, and I hope there's a question in this, but when I was looking through the chart and I was listening to the earlier presentations on biblical worldview for education, I couldn't help think of Islamic schools. Islamic schools have an Islamic worldview, a revealed law they believe is from Allah, the Sharia, and they teach that fully orbed worldview. So when it comes down to vouchers, how do we say, well, you can have it for this school, but you can't have it for that school? And do you think that the issue of Islam in the United States may push this to the forefront even more with what's going on?
It could push it to the forefront. I wouldn't give vouchers to anybody, including Muslim schools. One of the reasons the Attorney General of Oklahoma gave for opposing a Catholic school, online schools, is that then they would have to do it for Muslim schools as well, and the people of Oklahoma just wouldn't put up with that. So yeah, it would be a consistent, the state is out of the education business. If somebody has their school and they're not doing anything that's in the jurisdiction of the state to direct by force or violence, hands off.
So what do you think about the state requiring homeschoolers to a certain standard? Like when I was homeschooling, we had to prove to the state that our kids could read, that our kids could do math. Is that also state interference according to to your opinion?
Well, I think at some point the failure to educate your children might rise to the level of child abuse. So if something, the state does, I ask my students, okay, who has jurisdiction over children? And quite often they know me well enough. This is a trick question. Some answer right away, well, the family does. And then I ask them, what if there's child abuse going on? What about taking sacraments? So the different institutions are going to have jurisdiction, but it has to be for a particular purpose. So if it's something that we could say amounts to child abuse, maybe neglect, I mean, those are going to be tough. They're going to be borderline cases. Most likely, if somebody's not educating their children, they're probably abusing them physically in other ways as well. But basically, I would say the state has no. Jefferson's bill was adopted almost verbatim, but he had a line in there that I wish the Virginia General Assembly hadn't taken out. It said, the state has no jurisdiction over the mind. They have no jurisdiction over the mind. That's the basic principle. Some things are going to be hard telling where they fall, which side, abuse or freedom of the mind.
Hi. My question is so I'm 100% pro homeschooling. The reason, though, I've heard that the state gives for mandatory education is because if people are not educated, then they become dependent on the state, and so then you have the state welfare system who picks up the slack. And it seems to me that it's kind of like pulling a string out of a sock. That you've got a lot of things that are now, holding each other up. And how do we approach the whole system, not just the educational system?
Okay, if I understand the question, you're linking education, at least in some degree, to jurisdiction over welfare system, okay? Interestingly, in Section 16 of the Virginia Declaration of Rights, which Madison is quoting in this memorial and remonstrance, it says that basically the state has no jurisdiction over charity and love. Those are mutual obligations. So I would put it this way. The state has no jurisdiction over the mind, education. The state has no jurisdiction over the heart, welfare, love. Now, I know mind can mean more than whatever, but you get the point. Every time I think of that, I think of a very common phrase used during the Vietnam War. We have to win the hearts and minds of the people of Vietnam. You don't win hearts and minds by killing people and shoving things down their throats. Anyway, so I would say the state ought not to be in either of those. Okay. Now the other question is also very difficult and very important. If I understand it right, what do we do with those? What do we do with the system? Who's going to educate? Quite often it's who's going to educate the poor people in the city? Well, who's educating them now? It's a total terrible disgrace. Now, yeah, maybe this will step on people's toes, but when you consider all the money that goes into building stadiums, coliseums, and so on, the money spent on all of that, you could fund schools that would by private funds, far outperform the public schools, put them in different places in cities. I think one of the reasons, in addition to religion being out of the schools, and I'm not advocating religion being in public schools, is a consolidation school movement that took place in the late 50s and 60s along with that, where you have this big conglomeration of schools, I think so they could have more competitive athletic teams and supposedly more choice of subjects to take. I think that was probably as destructive as taking religion out. It takes parents, they're far more further removed. You don't need huge schools with incredible facilities. It takes teachers who love their students and are committed to it. It's their calling. In the state school system, I'm sure there are some in there. I know there were when I was growing up, but I think it's fewer and fewer probably.
Hi, Vic Canfield. From a perspective of law, how would you guide new homeschoolers or new private schools or such to be set up? And
For the legal wickets, I'm kind of thinking what Jerry Brown said, how he would handle the crime problem in California. Stay low and move fast. Maybe not have a high profile. Do you see what the locals are like? I mean, sometimes if you follow the laws that are out there, and maybe they're not properly laws, okay, I would suggest, is maybe you don't tell them. You just educate your children the way you're supposed to and have a fundamental right to do it. And I think that's perfectly lawful. It's going to be different in different places, I know. You have to go with what you think is, ultimately what you're comfortable with. The laws in the particular state and the advice and of other parents that are homeschooling and what their experience has been. That's about as much direction, I'm sorry, as I could give. I could say, well, I'm not licensed in Virginia, so I can't give you legal advice, but that wasn't legal advice. That was just general suggestions.
I want to revisit the Ryan Walters in Oklahoma, the school official who was mandating for Bibles in the schools and for the Ten Commandments. And so your response to that, I'm not sure I understood. Was the issue that he was mandating it, or was the issue the Bible's in the schools? And I believe he was mandating that the curriculum include the teaching of the Bible. If he had not pushed the curriculum piece and just having the Ten Commandments and the Bibles in the schools available, would that have made that case different? And would he have, not that there's a case right now, but he's no longer in that position because of, I believe, the mandating of it.
Yeah, my understanding is he wanted a Bible in every classroom, and he wanted the courses taught from a biblical perspective. Not sure totally what that means. And a Ten Commandments in every classroom, I believe, that he was putting out there. Now, that was separate from the Drummond case that I referred to. Just it wasn't dealing with the superintendent's particular issue. When somebody asks me, are you in favor of prayer in public schools, Bible reading in public schools, my answer is always no. There shouldn't be any public schools to pray or read Bibles in. It's beyond the jurisdiction of the state. It's a violation of the First Amendment as well. So, hanging on the walls, the court might uphold that. That's, I suppose, if a teacher's in a classroom, it would certainly seem they can have a Bible as well as any other thing. If the Supreme Court is serious that we treat religion and non-religion the same, it seems they would have to allow all of that as a constitutional basis. They don't want to be consistent in what they say. there's a tendency, a trend in the Establishment Clause cases to uphold vouchers, and in the free exercise cases to actually require states for certain purpose to treat religion and non-religion the same. If they were consistent with that, they would say you must fund public non-Christian schools equally to any other kind of school. But I wouldn't argue that that is even proper. I would argue that, as I did in those two briefs, in the argument that you at least out of practice and do what you say you do.
Okay, so can I add on to that then?
Sure.
So I have private schools that educate public education students, so they're placed in my schools.
Okay.
And I have boxes of Bibles available. If a child wants one, they can just take one. Would that be considered like crossing a line?
I don't know. That's a little different setup than I'm used to hearing. The closest I can come to a case called Aguilar, where the court said, case called Aguilar, that, and another case, Mitchell, that said the courts don't have to monitor what's going on in some of these classrooms where there's a combination of either public school teachers coming in or tutors or whatever else. Okay, I'd have to think about that. Somebody's going to complain, I'm sure, at some point in time, but the Supreme Court has gotten more religious friendly. I can put it that way.
One final question. It seems that not too many people are making this compelling argument that you're making, and three of them happen to be sitting in this room, Kevin Novak, you, and Kerry Morgan. My question is, what can we do to advance this case? Fighting the voucher, important as it is, and opposing it is a defensive position. And I think we can get on offense. What are we going to do to make this case get more attention?
Well, you're the policy guy. Kind of deflecting, I guess, in a way. I'm not sure in terms of strategies. I see at least my role as let's get the principles right so we know where we're headed and then try to figure out how to get there. Just like with the school system, how do we get from this mammoth school system to what we think would be right? Maybe it's carving up and renting space in the buildings that are there for private organizations, just for an example. Part of is an educational bit, and this, I haven't talked to Kevin in a few years on this, but I think one of the things Kevin found discouraging, if I'm incorrect, let me know, is that a lot of homeschool groups that he went to didn't say, this is terrific. It was more like, just so they leave us alone to do what we're doing. It's almost, as long as I've got my get out of jail free card, I'm not going to worry about others. That's probably too strong of a statement. They are worried, they're concerned, but maybe not jumping on it and becoming advocates for it. And I think in churches, a lot of them that would be sympathetic towards it, I think pastors are afraid to say something because it's going to create disharmony in their churches. People are going to leave and so on. I think that's part of what's going on. With what's happened here in the last few weeks, I had no idea Charlie Kirk was that big of a deal in all of these chapters and things of that nature. I'm wondering if something very big is about to happen and come to people's attention, and people willing to speak out and say things that they would have been afraid to say 3 weeks ago, I suspect.